Well, hello there. How is everyone? I hope you're all well on this fantabulous Tuesday. We're going to do... You're looking amazing, by the way. Absolutely amazing. I did a live earlier, and I was just conscious because we went through some docs. We went through some docs, and there was a lot. There was a lot there, and the live got to be like an hour long. And I know not everyone's got that time, so I thought I'd do a standalone video just to kind of summarise what is in the Idaho 4 docs, because it's kind of kicking off. It is kicking off over this situation where Ann Taylor has got this, professional firm. Let's just set the premise. This is a firm that has apparently operated in Idaho previously for the exact same reason. So they've been used to reach out to the community, to ask questions about the case, to try and understand whether there is bias in the community. So they've been used, they're familiar with Idaho, they've done this for 20 years plus, so it's not a new thing. And I've seen people in the legal community who have turned around and say what she's done is kind of pretty straightforward. But there seems to be a fucking huge problem with it, and we're going to touch on it now. So I'm not going to show you all of the docs because they're all kind of just repetitions of one another. But if I read you this last one, this kind of will give you a good understanding of what's being accused of Ann Taylor and Bryan Kohberger. So this is what we got here. So the state submits this reply to address two major flaws in the defendant's memorandum in support of his objection. First, defendant's explanation of how the survey complies with the non-dissemination order does not withstand even the slightest scrutiny. Defendant argues that hiring a professional firm to contact prospective jurors in Latah County and ask questions embedded with specific facts from the case does not violate the non-dissemination order because the embedded facts were already disclosed by the media. But with respect to both attorneys and their agents, the non-dissemination order prohibits any out-of-court statement which a reasonable person would expect to be disseminated by means of public communication that relates to several categories of information, including the identity or nature of evidence expected to be presented at trial or any sentencing phase of the proceedings. Defendant's interpretation that his attorneys and their agents can discuss with prospective jurors anything the media is already discussing would eviscerate the non-dissemination order. Nor can defendant credibly use as cover that the survey is asking questions rather than making statements. The mere fact that the identity or nature of evidence is being presented to the prospective jurors in the form of a question does not bring the survey into compliance with the non-dissemination order. The specificity of the facts included in the questions implies to the prospective juror that there is something to see here. Undoubtedly, such questions would draw quick objections in the voir dire process. Defendant also badly asserts that the non-dissemination order expressly allows the conduct in which his attorneys and agents have engaged, but he fails to quote or even cite the portion of the non-dissemination order he believes authorizes this conduct. Here we go. So, this conduct, where am I? We'll get rid of that bit. The state's best guess is that the defendant is referencing paragraph 2, subparagraph E, which allows the attorneys and their agents to request assistance from the public in obtaining evidence and information necessary to the state's case or the defense's case. Clearly, however, the subparagraph is a reference to general requests made to the public to obtain evidence or information about the case. For example, the attorneys or their agents could put out a statement indicating they are looking for any persons who were present at X location on Y date. Nothing in subparagraph E authorizes the attorneys and their agents to target prospective jurors and share with them specific facts about this case. So what they're trying to say here is that when they reached out, when they did this survey, they were actually giving specific facts or claiming them to be facts that were covered by the non-dissemination or the gag order. Now, they did in an earlier document try to say that the facts as well were untrue. So they've tried to basically say that they were saying that things were factual that weren't factual, and misconstrued things somewhat, or made them be misconstrued. Second, much of the defendant's memorandum and the entirety of the affidavit submitted with the memorandum are an attack on an argument the state has not made. The memorandum and affidavit go to great lengths to explain to this court that, as a general matter, jury surveys are not inherently improper for the purpose of a change of venue motion. The state has not taken a contrary position. Really? Instead, the sole legal basis for the state's motion is that in this particular case, this court's non-dissemination order prohibits certain questions defendants, attorneys, and agents chose to include in the survey. Given the state's, this court's, and at least up to this point's defendants' agreement that the non-dissemination order plays a vital role in protecting the integrity of the trial, the state filed its motion to bring this matter to the court's attention. So they're kind of trying to say, we didn't do anything behind your back. What you did, we feel that you were in breach of the non-dissemination orders, and we felt because of the gravity of it, we decided to bring it to the court. What they're basically doing is, this is now mudslinging, this is, but in my opinion, this is where Ann Taylor can go in there and say, look, I'm asking for stuff and you ain't giving us it. And people are then sort of, there'll be people who jump on the defence's side and say, why is it taking 15 requests for discovery? And this to me now is just becoming a game. Because this is now just mudslinging. This is now the prosecution's turn to come back and say, no, hold on a second. You've done this survey. You've gone out and you've broken the non-dissemination order. We're not saying that you can't do it. Of course, do it. We've done it and we don't see a problem with it. And we're not taking a stance on whether there should or should not be a change of venue. You do what you do. But how you're doing it is wrong. How you're doing it. You've agreed that there should be a gag order in place, and the gag order, again, you've agreed is needed to protect the integrity of the case, but yet you chose to go to the public and disclose facts to the public and they're trying to appear to say that you knew would be misconstrued if you twisted it. They're accusing her of jury tampering. Straight up. They're accusing her of jury tampering, and this is just turning into mudslinging. I can bet you bollocks to a barn dance now that there is not going to be a change of venue. Absolutely. This whole thing will now just get stopped. They won't be able to continue with it. The first round of these questions that were done in Latah County, it was stated that they would then have to do further surveys to other areas so they can do comparable data. And they're not going to be able to do it. They're not going to be able to do it. Therefore, this has just been a complete waste of time. And there will be no argument, nothing to get a change of venue. And I believe that's what the whole purpose of that was. Whether Ann Taylor has overstepped the mark, I don't know. Is there going to be an argument? Is there going to be more? Is this going to snowball into something else? But to me, they are fighting hard to keep this case in Latah County. And they're now doing so by destroying this work. Now, will they turn around and say, do it again and do it differently? Or will it just come to an abrupt halt here? We've got a hearing coming up in a few weeks' time that will, grab the bull by the horns and say whether this is going to be moved, but I can't see it happening. Let me know down below what you think, and I shall catch you all in the next one.